This is Colin O'Keefe with Monday's episode of LXBN TV. In what was an active week for the Supreme Court, the justices handed down an impactful ruling in Comcast Corp v. Behrend. Joining me today to discuss it is Katharine Parker, partner and co-head of the Employment Law Counseling and Training Group at Proskauer. Katharine, first, can you explain the facts and the background of the case?
Sure. I'm going to try to do it as simply as possible. Comcast was sued by customers in the Philadelphia area who claimed that the company had violated federal antitrust law in 4 different ways, leading them to have to pay higher prices for cable services. And they wanted to bring their claim as a class action. The district court dismissed 3 out of 4 of their theories of liability, but it found that one theory could proceed as a class action, and that theory had to do with Comcast allegedly acquiring competitors and clustering its operations in the market to deter competitors from entering into the market. The plaintiffs asserted that there were approximately 2 million customers in the class who paid higher prices as a result of this allegedly anti-competitive behavior. So what was at issue in the Supreme Court decision was whether or not the district court and then the Third Circuit had appropriately found that a class action could proceed. And one of the main issues that the court addressed concerned the method of proof of damages. The plaintiffs offered the expert report and testimony of an economist, Dr. McClave, to support their theory that Comcast actions had caused damages to all the class members. And the report made certain assumptions about the market, including that Comcast had engaged in all 4 types of the alleged misconduct, even though the district court found that only one of the types of misconduct theories was plausible and can proceed on a class basis. Comcast did not move to exclude that expert report at the district court level, but argued that that testimony and report was unreliable and irrelevant because it could not show harm to the class as a whole. And the district court decided that it did not have to decide whether the expert report was reasonable or, as Comcast argued, speculative at the class certification stage. And so the issue got teed up to the appellate court, the Third Circuit Court of Appeals, which upheld the class certification decision of the district court, and then Comcast appealed to the Supreme Court, which then looked at the issue.
I see. So, and second, this case seems quite technical, but can you do your best to describe the ruling and its impact in plain English?
Sure. The decision was a 5-4 decision. Justice Scalia wrote for the majority, and basically the court reversed the decision of the appellate court. It found that it was not appropriate to have certified the class. The claims could not proceed as a class action. And the reason was that the plaintiff's proposed damages model could not prove damages on a class-wide basis.
I see. Yeah, it's an important case, as we've seen a number of people write about it because it applies to so many different areas of law, having such a broad impact on class actions.
Yes, absolutely. It's going to have, I think it's going to provide a lot of good arguments for defendants who are resisting class certification, and it has broad application, not just in the antitrust context, but across the board. And the court reconfirmed some of the themes that it laid out in its Dukes Walmart decision as well.
Absolutely. It's been a huge couple weeks for class actions with suits both inside and out of the Supreme Court, and this is just another one in that line. Once again, that was Katharine Parker of Proskauer. Of course, be sure to visit us at LXBN.com for more of these LXBN TV video interviews, along with curated commentary from the Lex Blog Network's more than 8,000 members. Thanks for joining us today, Katharine.
You're welcome. My pleasure.